This week on The Communicators, a look at Google's new privacy policy with Marc Rotenberg of the Electronic Privacy Information Center and Mark Erickson of the Open Internet Coalition.
Well, on March 1st of this year, Google changed its privacy policy, and that's our topic this week on The Communicators. Markham Erickson is the Executive Director of the Open Internet Coalition. Mr. Erickson, could you explain what Google did to change its privacy policy and why?
Well, Google announced about 6 weeks ago that it was preparing to change its privacy policy. It's the first time I think a company of that size has given that much time and engaged in that kind of education campaign. But what they did is they took privacy policies, diverse privacy policies that apply to some 70 different products that Google provides, and they consolidated them into one single privacy policy that was uniform across all of those different products.
And what's the benefit to Google of doing that?
So the benefit to Google, they would say, is one, you only have to manage one privacy policy. And they would also say that they're able to provide more targeted services and more useful services to their users. So for instance, if you are using their Gmail product and you are inviting people to a party that they may know who some of your friends are based on your interactions on a Google social network and suggest friends that you might want to invite, and they're able to do that because they are working with you both on their social network as well as their email product. And for the user, what they would say is that it provides the user with one single privacy policy rather than having to navigate 70 different ones, and that it provides the user with a more consistent, uniform experience across all of their different platforms, and where they can get more targeted information, advertisements at each platform, so it'll be a better experience for the user as well.
And before we introduce our other guests, what is the Open Internet Coalition?
So the Open Internet Coalition is a coalition of leading internet companies, most of the big internet platforms, social media companies.
Including Google.
As well as small internet companies and startups. And it's a coalition that I run out of my law firm.
Also joining us here on The Communicators is Marc Rotenberg, who is Executive Director of the Electronic Privacy Information Center. Mr. Rotenberg, what is your group's viewpoint on the new Google privacy policies?
Well, we opposed it. We think the right way to think about what Google did is in terms of a change in the terms of service. In other words, before March 1st, Google had different terms of service for each of its products. If you were using email, for example, it collected your personal information to provide an email service. If you were using YouTube, it collected your information to provide the YouTube service. What Google wanted to do was to be able to combine all of that user information from its different products. And so it has simply told users that as of March 1st, the terms of service were going to change. It would combine all the data. It didn't give people a choice. They could essentially stop using Google, which I think for most people means stop using the internet. And we objected, as did many others.
Well, what's the damage that would be done to a user of Google?
Well, I think in the first instance, there's a genuine concern here about the company's commitment to users, the company's commitment to the privacy of users. Those privacy policies reflected in the terms of service essentially is what internet users rely on when they select a Google service. And if they choose Gmail, for example, over another service, and Google turns around and says, well, we had one policy before, but now we're changing it, the user's in a very awkward position, because the other thing that the companies typically do is collect a lot of the data to lock the user in, so that your address book, for example, which you build up in the context of a particular service, makes it very unlikely, or certainly not easy, for you to move to another service. So we think it was unfair. We actually brought a suit here in Washington. We sued the Federal Trade Commission, which surprised people. People said, well, why don't you sue Google? And we said, well, we're going to the Federal Trade Commission because Google's actually under a consent order, in part because of an investigation that we had urged the FTC to pursue to respect user privacy. We thought the changes that Google had announced violated that consent order, and we sued the FTC to try to get them to enforce it.
Our guest reporter this week is Paul Kirby, Senior Editor of Telecommunications Reports.
What should they have done, Mark, in your view? Should they have said, okay, here's what we want to do, you can opt out of this, or how should they have done it?
Well, I think the best way to have done it would have been by opt-in. In other words, Google could have said to users, listen, we have a new approach. We think it's going to provide some benefit to you. We think you'll get advertising that you're more interested in. We understand that we have a commitment to you right now in terms of our current privacy policies, but we'd like to give you the opportunity to choose our new integrated Google platform. And users might have said, hey, that sounds pretty good, I'll sign up. And certainly we would not have objected if Google had done that, because so much of the internet is about choice. I think the less good alternative would have been for Google to say, listen, we really want to do this. We're not sure if everyone will agree or accept it, but we respect that some people might not. We'll let those folks opt out. So before March 1st, you can make a choice. If you want to opt out, this is how you do it. Google didn't even do that. And I think the other point worth making here, differing a little bit with Markham's earlier comment, when Facebook proposed a similar change in its terms of service back in 2009, led to a public discussion. People said, we actually don't like this idea. Facebook said, you know what, if you don't like it, we're not going to do it. So another option for Google actually would have been not to go forward with the change after they heard the criticism. But they took none of those options. No opt-in, no opt-out, no withdrawal of the proposal. They simply pushed forward.
We don't have Google here, but Markham, do you want to respond to what Mark said about how he thinks they should have proceeded?
Well, you don't opt out of privacy policies. It's a policy, and a policy is something that a company states is how they are conducting their business. When you go to the Washington Post website, you can look at their privacy policy, and you don't opt out of a policy. I think the response to Mark, and I respect where Mark's coming from, but I think Mark's point of view in this space, and has been, is a different point of view than how we've handled privacy with regard to the commercial internet since the inception of the commercial internet. And I think Mark objects to that, and I understand that, but his criticism really isn't about Google. It's about the privacy policies across the commercial internet, because Google's policy is consistent with the policies of all the major social networks, with companies like Microsoft and companies like Yahoo. If you think about a Facebook, they have a lot of different products and services under one platform. Google is essentially a platform, but those products are across different pages, so you don't go to one Google site to get all of those services like you would with a Yahoo where it's one portal, or a Facebook where it's one portal. So what Google said is, we're going to essentially do what those social networks and those portals do, which is to have one policy that applies to our products. The trade-off is this, and this is one that I think Mark bristles with. The vast majority of consumers, in the 90%, are okay with this concept that these social networks and companies like Google provide free services, like web-based email services, like mapping services, like search services. And they do that for free because they're able to sell non-personally identifiable information about the things you do on the internet, the browsing habits you have, whether you go to sports sites or whether you go to shopping sites. And they're able to tell advertisers that this user, and again, it's not personally identifiable, that this user on this computer happens to like sports sites. And so they're able to sell you ads that are more relevant, and they're able, because of that ad revenue, then to provide those free services.
And you're saying people understand in this stage of the internet, ads free comes with ads, and people are willing for that.
People understand that, and people want ads that are more relevant to them. If you're into sports sites, you don't want to get ads necessarily about shopping sites. And so the ads are more relevant, and so it works for the companies to provide the free services, and it works for the users because they're getting more targeted information. Mark has a very European approach about privacy, which is that the information itself is data and information that you should have much more control over, even if it's non-personally identifiable. That's a European perspective that's been rejected in the United States to date. We have a tort-based system, which is it's not the information in of itself, it's how you use the information, whether that can be used in a way that would be inappropriate, would harm you. The expectations that users have and what Google's doing are consistent with the expectations that you have when you go to the internet. So when Google announced that they were changing their policy, the users could have decided to revolt. They didn't. In the Facebook situation, there was a lot of consternation. There hasn't been that kind of consternation because what Google has done here is essentially consistent with what these other sites do. The second issue is that the Federal Trade Commission has objected to Mark's lawsuit. The Federal Trade Commission governs this space. They are able to enforce the consent decree they have with several of these large internet companies through their statutory authority, and they do that. And that's the appropriate governance here. But I also think, to anticipate what Mark might say, that we should have some privacy legislation, that we actually should have a more robust framework so that these complicated privacy policies, and they're complicated, could be put under a system of either best practices or some sort of legislative framework where you'd have a federal government seal of approval for practices that are consistent with user expectation.
Mark, you started shaking your head when Markham said 90% approve.
I don't know where to begin. I mean, I think Markham's just making this stuff up. Let me try to answer some of the points that he made. First of all, this is hardly my view with respect to the concerns about the change in Google's privacy policy. You had 36 state attorneys general objecting. I don't think they're in Europe, by the way. I think those are states within the US. You had congressional leaders in the Democratic and Republican Party objecting. You had 60 consumer organizations from the United States and Europe objecting. In fact, I would challenge Markham to come up with a move made by an internet firm so far this year that has been more controversial than Google's March 1st change in its privacy policy. I can't come up with one. I think they've left themselves wide open to a lot of criticism. But here's the most interesting number, and that is, what is the view of internet users? Markham said that internet users have accepted this idea that they give up personal information for free use of the internet. And I'd like to ask him to put some fact behind that, some research, some report, some study that lends credence to that claim. And the reason I say that is because I recently looked closely at the Pew study on internet life. They conducted a very extensive survey on America's use of search engines. Fascinating survey, by the way, most comprehensive review that's been done probably in 7 or 8 years. They found, first of all, that 92% of American adults use a Google product every day. Vast majority of search is done on Google. They found that 68% of people using those products object to personalization, object to page rankings based on personal interest, and 73% were not okay with the idea that personal data was being collected to generate search results. So on this critical point, apart from the fact that what Google did on March 1st was widely opposed by just about everyone who considered the issue, except for, I think, a small group of Washington lobbyists, as to the view of internet users, I think there's a clear majority against what Google is doing and other companies that rely on personal data in this way.
Well, I think this is the problem, is we mix apples and oranges. What Google's doing is not sharing personal information under any widely accepted standard that we have in the US government with third parties. They share anonymized information about browsing habits to deliver more targeted advertisements.
Really, do you make this stuff up? Google admits that they keep user-identified search histories for 18 months. The entire debate about anonymizing search histories has to do with a period in time at which Google decides to anonymize the search history. Even they wouldn't say that it's not user-identified, so why do you say
Mark,
this?
This is where you're mixing apples and oranges respectfully.
You're saying things that aren't true.
It's not. That's absolutely wrong. Google does not share personally identifiable information with third parties. Do they collect personally identifiable information that they keep?
Right.
Yes, and so do many other
So what do they do when they get
websites.
subpoenas or search warrants?
Again, Mark,
they're non-responsive. You just said a moment ago that they don't disclose personal information to third
if
parties.
I may, you are mixing apples and oranges. Government access to personal information is governed under
Are they a third party?
And under our Fourth Amendment jurisprudence. What you're confusing is law enforcement access to information that not only Google has, but every website that collects personally identifiable information, shopping sites that collect your credit card information, sites that collect your address, and the government has access to that upon subpoenas or lawful process under our electronic surveillance laws.
But
that's
just,
a
You're
different
saying commercial third party.
I just
We're
said that they
talking
don't
about-
disclose the
if I may,
information to third parties.
information.
Mr. Rotenberg, you can answer as soon as you
Okay.
Information. When they get subpoenaed
I
by
teach this
law
stuff.
enforcement,
Yes.
yes, then they are required to do so.
Mm-hmm.
And if you object to that, and I agree there are concerns in that space, we should change the laws that govern when law enforcement can access and how they access personal identifiable information. That's not unique to Google. That's the case across the internet. I agree that there's concerns there. That's not what this issue is about.
It's absolutely what this
If
issue is
you
about.
wanna-
Wait, just a
It
moment.
is
Let me
not.
answer these points, because you say things that aren't true, and if I don't have the opportunity to respond, the viewers of this program are going to think what you're saying is correct. Now let's consider the point that you're trying to make. What you're trying to argue is that it's different when law enforcement gets access to the information that Google keeps about its users from Google disclosing that same information to third-party commercial providers. Yes, and you're saying that all companies are subject to these law enforcement requirements, which is also true. However, and this is the key point, Google makes the decision to keep far more information about internet users than any other company does. And because they have made that decision, because they retain more data about Google users, they leave those same people more vulnerable to those law enforcement requests that they know inevitably will come. And other companies which care about this issue make the decision not to keep so much information. They can delete search histories in 2 days, they can anonymize within 6 months, but Google says, no, we don't care about that issue, and therefore we're going to retain the data. And this is a very important point to understand, because when Google chose on March 1st to combine the user data, they also made users more vulnerable to law enforcement requests. Now the copyright investigation involving YouTube means that it's not just a YouTube user's information that will be disclosed, it means that a Google user's information will be disclosed, which is not just the YouTube record, it's across the 70 Google services.
That's absolutely wrong. And I'm not actually sure why you're saying that what I'm saying is incorrect, because there is no criminal copyright investigation against YouTube. There's not. There's civil lawsuits, which is governed by an entirely different statute and framework than when the government asks for that information. And under our laws today, the civil actors aren't able to get personally identifiable information for their copyright investigations. In fact, that's what the Southern District of New York said when Viacom sued YouTube. So it's actually wrong to say that users are currently under a threat of access on their YouTube viewing habits in some sort of current investigation. It's absolutely flat wrong. There is a criminal standard, as you know, that applies to government access of information. And in fact, Google, as well as many of the large internet companies, are leading the charge to amend the laws to ensure that that a subpoena is required for personally identifiable information to make a user's expectation about what's private for them when they're keeping documents or storing other things in the cloud, that it's the same framework that they would have if they're seeking to get that document, the government that is, from your home. That's the appropriate framework. Google collects more information about users mostly because they're one of the bigger companies, so they have more information coming in. If you compare the information they collect to a smaller search engine like Ask.com, Ask doesn't get the volume of information coming in that a Google does. So part of the reason that they're getting so much information is because they have more users. When the government accesses that information, when they're the third party, Google actually has fought the government more times than any internet company I know of to say that users have a reasonable expectation about privacy in this space. I think what most viewers are thinking about when they think about this space is actually non-governmental third-party entities, commercial entities, and what information they get access to.
So can we talk
and
about
in that
this issue?
space, they don't get any personal information. So that is the case.
Mr. Rotenberg.
All right, so I mean, this is a good, lively discussion, and let's take up the second point, which is the third-party disclosure to commercial actors. And you, as I understand your argument, you want to give a lot of credit to Google for not disclosing user information to third parties. And the obvious answer is that Google is dominant across so many essential internet services. It doesn't matter whether it discloses the information to third parties. What matters is the sharing within the largest internet firm in the world, between an email service, between a video platform, between a mapping service, between a photo sharing service. All of these are Google services. And what Google does by combining that information is to consolidate its monopoly position. It would be adverse to Google's interest to disclose user information to third parties because Google is not interested in creating competitors or creating choice for users of current Google services. It's completely consistent with their model to keep the information internal. And this actually underscores the significance of the March 1st decision, because what Google did, in addition to changing the terms of service and reducing the privacy protection for internet users, it also consolidated its control over so many of these key essential internet sectors. And that's troubling to me, not only for privacy reasons, but also for reasons of competition and innovation, because I think the internet does thrive when new firms can come along with a better idea, can compete, and can draw users. What Google is doing now by combining these policies is actually making it more difficult for others to participate in the internet economy. And the thought that somehow it's a benefit that they're not disclosing user data to third parties is actually a reflection of their aim to have as much control across the net as possible.
But this is what's so frustrating about this conversation. So you've acknowledged that Google doesn't share, and it's not in their interest to share sensitive personal information with third parties. I thought that's what this debate was about. Then you pivot to say, but the fact that they're not sharing with third parties is troubling because it prevents competition. That's a totally different issue, and it's actually one that is being looked at and should be looked at by Competition Counsel in various jurisdictions. And Google should be looked at, and they do, and they have to defend themselves on whether they're acting lawfully or not. I think they have a good case to make. But the competition policy side of this is totally different than the privacy policy side of this.
Mark, let me ask you a question. You said the new policy allows them to consolidate power. They currently had privacy guidelines for those individual services. They consolidated it. How did that allow them to consolidate their
Well, because key to understanding a privacy policy is that individuals provide information that's relevant and necessary for the service they're signing up for. And we know this in quite a bit of detail, specifically with regard to Google, because of what happened with the introduction of Google Buzz last year. So when Google was trying to enter the social network space and compete against Facebook, and they had a large base of Gmail users, and they wanted to introduce a social network service, and they weren't sure how to populate it and whether, affirmative consent would draw enough users, they basically decided to convert their Gmail subscribers into social network Buzz subscribers. And the personal address information that was in the Gmail account holder's record was made available publicly to try to launch the social network service. And we went to the Federal Trade Commission and we said, this is terribly unfair. It's terribly unfair because people who signed up for Gmail, signed up for an email service, they're finding their personal information that they thought was in an address book now widely accessible on the internet. Google, interestingly, I think agreed with us. They probably wouldn't say that publicly, but they pretty much conceded that it was a mistake to introduce Buzz as they did. The FTC launched an investigation, ended up agreeing with us, required a comprehensive privacy program for all of Google's products and services based on what had happened with Buzz. And this is the key point that bears restating. The information that people had provided for an email service, they didn't expect to be used for a social network service. And so when Google came along at the end of January this year and said, oh, that information that you provided for Gmail, we're going to make it available across all of our services, we understandably,
it's the same thing, but
yes,
on a larger
exactly.
scale,
We understandably went to the Federal Trade Commission and we said they simply can't do this. It violates the consent order. Now, the case that we lost wasn't on the merits. In fact, the judge agreed with us that the Google change raised, in her words, serious concerns. She simply concluded that federal courts didn't have the ability to force the Federal Trade Commission to take an enforcement action.
Did that surprise you because consent decrees are approved by courts?
Well, we thought this consent decree had not been approved by a court, but it was a final order from an agency, and we actually thought we had a pretty good legal argument.
As any final order from an agency, whether a consent decree or rulemaking.
Exactly, and the enforcement provision for the FTC actually says, in a non-discretionary fashion, that fines shall be imposed. So we went to court and said there's a consent order, it's a final order, it should be enforced. The agency is required to enforce its orders. But as I said, we lost not on the merits. It's simply a question of judicial review. But coming back to Markham's point, I mean, obviously we have different perspectives on this issue, but I think it's very important in this whole debate, between the privacy groups and people representing industry, not to lose sight of the interests of users, because it really is their data that we're talking about. We're talking about how personal information is being collected by firms, how it's being used, whether their privacy is being respected or whether it's being ignored.
Markham Erickson.
Personal information, though, Mark, is not being shared with commercial third parties. That's not what this policy is about. Google has entered into a consent agreement with the Federal Trade Commission that is one of the most robust in the space. Several of the other internet brands have done the same thing. They're subject to 20 years of audits from the Federal Trade Commission to review their policies. The reason I suspect your organization went to the courts to try to get action was because you were getting rebuffed from the Federal Trade Commission that has the authority in this space, is able to enforce their consent decree. If they think there's a violation of that agreement, they'll take appropriate action.
Yeah, I think it was not true. We were never rebuffed.
But then it was inappropriate to go to the courts, and that's what the Federal Trade Commission said.
Well, Marc Rotenberg, do you see other companies using the Google model as their own model in the future?
Well, I don't think there's any other company that dominates the internet in the way that Google does. Now, clearly Facebook is a competitor to Google, and I think we can understand a lot of what Google is doing today in terms of their concerns about Facebook gaining greater control over what is ultimately a battle for advertising dollars. I mean, both companies rely very heavily on advertising dollars. That's their core business, and they need to provide services that will draw users. But no other company is in Google's position, which is why we maintain this focus.
But as private companies, and if they're clearly stating what their policies are up front, shouldn't they be allowed to proceed?
Well, I think they can if it's fair to the user. I mean, we have to understand, for example, how these policies operate. And one of the business concerns that the Federal Trade Commission has always been sensitive to is the notion of bait and switch. And it operates in this field. In other words, a company can say to a customer, we have a great privacy policy. You should sign up with us. We'll respect your data. We won't do anything wrong with it. And the user says, hey, that sounds great. I'm going to pick you guys. And they build up a big address book, and they build up a social network, and they build up all sorts of preferences. And then a few months later, a year later, the company says, well, we've kind of got a new business model now. We're going to try things a little differently, and we're going to change that privacy policy. Now, we think it's going to be really good for you, and you're going to like it, but what we promised you before, we're not going to do anymore. And that's the basic problem for users. It is this sense that companies will try to draw them in with an attractive policy, but once they've got them, then the rules change.
Markham Erickson, final word, and then we're out of time.
Well, I think that when a company spends 6 weeks educating its user base about a change of policy that they believe is helpful to users and will make their product better, they shouldn't be punished for the fact that they've tried to set the expectations by not baiting and switching anybody, but actually saying to their user community and highlighting, this is what we're about to do 6 weeks from now. And so that kind of bait and switch tactic, you're right, should be gone after. It has been gone after in the past. You've led the charge on some of those issues, rightly so. This is simply not one of those cases. And I think respectfully, some of the criticism about collecting information and what laws should apply in that space are proposals that have been rejected by mainstream policymakers in this space since the beginning of the commercial internet. That is a conversation that we should have, but the criticism about Google, I would respectfully say, is more of a criticism about the commercial internet, not about one company.
And unfortunately, our conversation time has ended. We have been joined by Markham Erickson of the Open Internet Coalition, Marc Rotenberg of the Electronic Privacy Information Center, and Paul Kirby of Telecommunications Reports. Thanks for being with us.